Hello, everyone. Welcome to today's webinar on how to increase your odds of success for your H-1B program. I'm going to give it just a quick minute or two to let some others join us, but you are in the right place and you are here at the right time. So just give us one more minute. If you do have any questions, feel free to either raise your hand or pop your question in the chat channel. We'll cover those at the end of the webinar. All right, in case you've just joined us, just a little reminder, make sure you're in the right place. This is the webinar on how to improve your odds of success for your H-1B program. If you have any questions, feel free to pop them in the chat or you can raise your hand. At this point, we're going to go ahead and get started. As I said, we are going to review how to increase your odds of success for your H-1B program. First, I'm going to tell you a little bit about our firm and our presenters today. International Legal and Business Services Group has been supporting clients for over 15 years. We work with companies of all sizes as well as individual clients. Our clients continually rate us very highly, really focusing on our personal attention, our attention to detail, and our open communication. We are certified minority owned. We're also minority staffed. We are certified minority owned. And we also have a quality management system certification, which is really above and beyond. There's not many law firms that really offer that. And that demonstrates our commitment to continual improvement and efficiency. We're also active in the community as members of the Chicagoland Chamber of Commerce and 1871. Our firm is 40 plus people strong. We have a variety of backgrounds and offer 12 different languages. Our attention to detail and our cultural sensitivity is really beyond measure. And with the benefit of additional languages and the cultural sensitivity, we really overcome a lot of issues that can creep up during the immigration process. So that's another thing that really sets us apart. Our presenters today, Praveen Medakundam is a partner with ILBSG. Praveen is licensed in the United States, India, and the United Kingdom, and has extensive experience with both company and individual immigration. Amaru Lulseged is a managing attorney with our firm, and he has extensive experience in immigration and specializes in multi-project filings. Julia Funke is also a managing attorney with our firm, and again has extensive experience in immigration and specializes in USCIS inquiries. To start us off today, Praveen's going to give us an overview, kind of our perspective on what the H-1B program looks like. Praveen.
Hello, everyone. Good afternoon. We are back again for our H-1B filings, the quota filings which start in March. So this is time for all of us to get geared up to prepare and also to know if there are any changes which helps us prepare well. Then I would like to just touch base on a few updates on the H-1B program, which might be beneficial for all the viewers, participants to understand and plan things accordingly. H-1B petitions, when we filed last year, has a huge backlog. The processing times were delayed substantially because of the pandemic and processing delays from the USCIS, probably because of the staffing issues also. Then we saw H-1B petitions pending for more than a year in some of the cases, but an average was around 10 to 12 months when we filed it in regular processing, and that actually encouraged most of the people to file it in premium processing. So we have noticed that the backlogs have been improving recently, but not substantially again. but definitely we see that these things are getting better day by day, but we don't know how it looks like with the new wave of the pandemic situation. So with that background, then we are preparing for the new H-1B quota filings starting in March. Then the old system of lottery remains in place. That means employers are required to register on the USCIS portal by paying a fee and then wait for the lottery results till the end of the March. Then you get 90 days to file the H-1B petitions. Then the policies are a bit uncertain at this point, so it needs more focus for all the employers who are preparing to file for the H-1B petitions at this point. The wage level lottery was proposed, but again, the current administration did not defend it. It still goes through the normal process what we had in the previous fiscal years. But again, the current administration, as you all remember, that they supported strongly for wage level selections. So that might come back in some form, maybe through a legislation, we don't know. So we have to also focus and wait for that. And there are also some pending litigations at this point, because the current lottery system is giving undue advantages to some people where they go through multiple employers just to circumvent the quota. And as a result, we have seen 2 continuous fiscal years that the lottery system has unfairly selected some people who probably filed through multiple employers and did not end up availing the quota. So we had lotteries at various times. Again, the first lottery and the second and the third is that the whole result of the lottery system, which was unfairly giving some advantages. So probably if the litigation goes further and if there is a judgment says supports that there is unfair distribution of the whole quota system, then it might go back to the paper filing. So we got to watch out if there are any changes from now until the March 1st week to just see if at all that would impact the current lottery system. Then the DOL also probably is increasing the wages pretty much. So that would have an impact on the way that we prepare the petitions and the preparation for the employers to consider those wage changes as they come along. Then certain things that we anticipate requires executive office actions. So just an example, that H4 and H4 EAD petitions probably need a premium processing because there is undue delay in processing those applications, which puts a lot of burden on the families when an H-1B petition is considered in the premium and the H4 is not. So again, the H4 renewals are taking more than 10 months and sometimes even more than a year, which also impacts their ability to work on the H4 EADs. So those kind of things needs an executive office action. Probably you'll see those kind of changes. We need to pay close attention for any policy changes for that, including biometric requirements, probably delaying the whole process. So then, in fact, a new situation has arisen due to a lot of demand for technology workers, especially who are working on the H-1B, that we have multiple offers, multiple job offers for people who are on H-1B. So there might be some policy guidelines coming in place where employees would be allowed to work on multiple projects. And if at all, USCIS considers the situation, and they might throw in some guidelines on how to address this situation. But otherwise, it is fairly unaddressed. And the need in the market is that the technology workers are overwhelmed with projects where they are in a position to support multiple projects. So those are the things that probably would impact the whole preparation for all of us in filing these petitions. But again, continued gridlock in Senate is also hampering our whole system in H-1B to file the petitions as we anticipate. then I also anticipate that the federal USCIS filing fees would be increased because that's also in the discussions, and because of the increase in agency costs, probably we'll see those fees going up in the near future. So the H-1B program as such has gained a lot of momentum because of the need in the current economy, but at the same time needs a lot of policy changes and needs substantial action from the Congress and Senate. So we have to wait for those changes. But as it looks like, the H-1B program has been well programmed, well organized at this point, with very low rejection rates compared to the previous years. So that's an encouraging factor. But otherwise, increasing in site visits and delays in the processing are definitely impacting employers who are ready to hire foreign workers for different programs that they want to implement in this current year. So with that, I think we'll get to the next slide, Tuti. So preparation is the key. So when we are even registering for the H-1B program for the quota in the coming March, probably getting into the background of the projects that the employees are supposed to work, including their education and experience background, has to be well prepared for, because you do a registration, then a person, an employee, a prospective employee gets selected. But at the same time, when they actually prepare to file the petition, then these things come up for the discussion. It could be the wage levels, it could be the project that they're assigned to, or even their education and experience. So even though the lottery system does not demand for you to actually have more details to register, but it's always key for the success of the H-1B petition to evaluate, to review all these details upfront, and our team can definitely help you when you are doing this. The key to the success and the key to the preparation for the whole program is to review thoroughly even prior to doing the registration of the employees on the USCIS portal. So again, the advice from us would be to submit as much as more information as we could, because for the H-1B petitions, it's always tricky that even though the current policy guidelines from the USCIS or the president tells us that we don't have to submit an itinerary, or otherwise the client letters are not mandatory in most of the situations. But that's the key to the success and implementation program, and especially meeting the compliances under the H-1B program. It's always suggestible to submit as more information as possible. So monitor closely again for the changes that we were discussing, so that that impacts the H-1B petition filings in the next few months. So again, timely response on RFEs, again, proper filing when a petition gets selected in the lottery, when a registration gets selected in the lottery, then we need to submit the petition within 90 days. So the timely response for all these things are very important. Then employers can closely work with our team in getting these things organized, so we can give an individual advice based on their situation and the target filing requirements. With that, I think we'll go to Amaru, who will present on start with the outcome in the mind.
Thank you, Praveen. Yeah, I kind of jumped the gun on that last slide. So next up, we have Amaro Lulseged, and he is going to review with us how to start with the outcome in mind. So Amaro.
Thank you, Praveen and Dorothy. So the H-1B program is a federally administered program that allows companies and other employers to temporarily employ foreign nationals. There are two major requirements for this H-1B. One is the specialty occupation, and other is the degree requirement. By specialty occupation, it means that the H-1B program it applies for occupations or jobs that that require a minimum of a bachelor's degree in a specific field of study. So as long as the job requires that minimum bachelor's degree in a specific field of study, it will qualify for the H-1B visa. The degree requirement, on the other hand, is the foreign workers field of study degree has to align with the required specific field of study. So, meaning the foreign workers bachelor's degree, minimum of a bachelor's degree, will have to align with what the job requires. At ILBSG, our approach is to file a correct and complete application and then avoid by any means the possibility of RFEs. Although RFE is not totally avoidable, but by preparing documents completely and correctly, you will significantly minimize the chances of RFE being issued. And although this days the number of RFEs has significantly went down by USCIS, USCIS still issues RFEs in areas such as qualifications, questioning the qualification of the employee, maintenance of status, specialty occupation, meaning questioning whether the offered position qualifies for the H-1B program or not, and sometimes about employer information, asking basic company information, incorporation information about the employer, and more often about regarding to in-house projects and multiple projects. Whenever a petitioning is for an in-house project, USCIS would like to see some documents specifically addressing those projects. So before filing any H-1B, the most important steps are designing the title of the job, designing and crafting the duties, choosing the SOC code, and for the LCA. These are very important steps that you need to absolutely consult a qualified attorney in order to determine the correct title, and then craft the correct duties and pick the correct SOC code in order to be successful in the H-1B application. The job duties have to be crafted in a way to demonstrate that the beneficiary or the employee will be doing a complex duties that will require a minimum of a bachelor's degree, because that's the whole definition of a specialty occupation. The SOC code is the code that we put in the LCA before it is certified by the Department of Labor. So USCIS looks at this SOC code to determine what the job requires and what is the nature of the job. So these are very important elements and steps to take. The other points to make a note is the job duties, the job titles, SOC code, and also the requirement that you state that the job requires has to be in line with the Occupational Outlook Handbook, the OOH, and the O.NET data collection. These are the database that the Department of Labor usually has and updates from time to time. And this is the database that USCIS consults in order to verify whether the offered position qualifies for a specialty occupation, and whether the beneficiary also qualifies for the offered position. And you have to make sure at last that the beneficiary's background matches with what the job requires, as specifically stated in this OOH and O.NET databases. So filing the labor condition application, which is also known as LCA, is the very first step before filing the I-129 form with USCIS. The labor condition application will contain important information, including the job title, the SOC code, prevailing wage, and the work locations. And in the work location, you have to make sure that you state every client, every end client that the beneficiary is prepared to work for. And due to COVID-19, if there is any remote location work, that also has to be included in the LCA. When it comes to multiple projects, when it comes to multiple projects, the USCIS has not released any formal guidance on how to approach this, but due to COVID-19 pandemic, it opened an opportunity for beneficiaries to be able to work on more than one project, meaning work for more than one end client. At ILBSG, we filed several multiple project applications, and so far we have been successful. In our approach, we are listing all end clients and all work locations in the LCA. And also we are submitting all end clients, vendor letters, end client letters, and contractual chains for all of the end clients mentioned in the LCA. So at LBSG, our approach has worked and we successfully filed several applications on this. There are different kinds of applications when it comes to H-1Bs. There are amendments, transfers, extensions, and amendment with extensions. For amendment applications, you have to make sure that you will be filing the application with USCIS well in advance of any material change occurring on the approved employment. So when you prepare to file an amendment application, you have to take that into account and give you self-sufficient time to file a LCA, get that certified, and then file the application before the change occurs. Transfer application is switching from one H-1B employer to another H-1B employer. And here, what you have to bear in mind is if the beneficiary lost his or her employment, you will have that 60 days grace period to file for the transfer application, finding a new employer. That is either 60 days or the I-94 expiry, whichever is shorter. When it comes to pure extensions, USCIS allows beneficiaries to file as far as 180 days in advance of the current H-1B expiry. When amendment plus extension application is filed, it has its own benefits. One is you are no longer bound by the 240 days rule, meaning as long as you timely file that application, the beneficiary can continue to work past the 240 days after the I-94 expiry. And this application is also not bound by the 180 days. The application can be filed way more than 180 days prior to the current H-1B expiry date. So at ILBSG, our approach is filing as much as possible the complete document and complete application. Like I say, they will significantly reduce the possibility of getting an RFE. By complete applications, we mean for qualifications, considering the beneficiary's educational background. This could be an evaluation or an experience opinion letter. And maintenance of status, if this is a normal H-1B transfer or an extension, we're referring to pay stubs and right to control documents. If it is a student, then student-related documents, including the I-20 and any employment authorizations. Special occupation, this will include any any expert opinion letters, or the databases that I mentioned earlier, the OOH and the O.net, to prove that the position is indeed a specialty occupation qualifying for the H-1B. The other one is the in-house and multiple project documents. These kind of petitions will require significant amount of documentation in order to support all end clients that are mentioned in the LCA, or in case of in-house projects, in order to show what the beneficiary will be doing in-house, including the technical description of the project. So all this complete documents filing will significantly lower the chances of getting an RFE. The last step that you need to take before filing the application with the USCIS is to make sure that you are avoiding rejections. Rejections can have severe consequences for the beneficiary, especially if you're filing at the last minute. By the time the case is rejected to you, and by the time you refile the application, it may be a late filing for you, which will have consequences for the beneficiary's maintenance of status. So always check for the filing addresses. This is, you need to consult the USCIS website every time you file applications, because they will change the filing locations, and sometimes they will not give you an advance formal notice. You have to verify the form additions as well. At the bottom of each page, you will find an addition date that USCIS is currently accepting. And you have to make sure signature every page is signed where it needs to be signed, and also the signature complies with the USCIS guideline. So you have to make sure that your complete application, starting from the LCA filing that like we discussed, to documentation your case, and then submitting a complete application, will avoid any unnecessary rejection by USCIS.
Thank you, Amaro. You did answer one of the questions that was submitted prior to the webinar of how long someone can stay in the US if they've been let go or have had a job change, haven't yet found a new job, and I believe that answer was 60 days. So,
or I-94 expiry, whichever is shorter.
Right. Thank you. Thank you for that clarification. Thank you, Amaro.
You're welcome.
Okay, next up we have Julia Funky, and she's going to walk us through what to do after you do the filing.
Thank you, Dorothy, and thank you, Praveen and Amaro. So as Dorothy mentioned, I'm going to talk about our recommendations for after filing, including various outcomes and inquiries from USCIS. So first up, we have approvals. After filing, obviously the most desired outcome is a straight approval without any further request or inquiry from USCIS. In 2021, we've seen an unprecedented rate of straight approvals as the current immigration climate continues to be extremely favorable for employment-based immigration. So what is that likelihood? So in 2020, nationally, 28.8% of cases received an RFE from USCIS, which was a decrease from 40% in 2019. So that was really encouraging. At ILBSG, only 15% of cases have received an RFE in 2021. So 85% of the cases we filed received a straight approval without any further requests or inquiries from USCIS. While straight approvals are certainly more common than in past years, there are various kinds of inquiries you can receive from USCIS after filing an H-1B petition, including RFEs, notice of intent to deny, and notices of intent to revoke. So I'm going to walk through these next. And first, I'll talk a little bit about requests for evidence, since those are the most common. For starters, while we've seen major increases in straight approvals from USCIS, RFEs are still common and a realistic result of filing an H-1B petition if any further documentation is needed to substantiate your request for H-1B status. Like Amaro said, not totally avoidable, but there are things that you can do. RFEs are typically issued for one of two reasons. First, they'll be issued to request further documentation required to substantiate that one or more of the H-1B requirements have been met. Or sometimes they're issued to request a clarification or an explanation regarding something in the record. So something that you submitted at the initial stage that USCIS maybe has questions about or wants clarification. In previous years, work itinerary RFEs were the most common kind of RFE. So a work itinerary RFE would ask for further documents to substantiate what the H-1B employee would actually be working on. So this was particularly true for IT companies, where there's often a third party end client that would be benefiting from the employee services. However, following federal litigation in 2020, work itinerary or project related inquiries are basically non-existent. We just simply have not seen them over the last 2 years. So that's why RFE rates are down in general, is because USCIS is no longer questioning the work to be performed at the same rate, particularly in the IT industry. So that makes this a really favorable time to file an H-1B. Now that work itinerary RFEs have been practically eliminated altogether, the most common RFEs we see these days are maintenance of status, beneficiaries qualifications, or for specialty occupation. So ways that you can avoid getting an RFE One of the best ways to avoid getting an RFE is to work with an attorney at the initial filing stage. I can't emphasize that enough. That will ensure that you file the petition with the strongest possible LCA using an excellent SOC code that perfectly suits both the position at your company and the candidate's background. While some companies may be tempted to file the I-129 petition on their own and then hire an attorney only if they get an RFE, the best approach is to have strong legal representation from the very beginning, and that'll reduce the chances you're going to get any further inquiry. When filing the I-129 petition, as Amro talked about, it's very important to submit all the required documentation up front at that initial filing stage. Having an attorney thoroughly review all your documents for inconsistencies or missing information is a really great way to ensure that USCIS has everything they need upon filing to approve the case. And that should always be the goal, to file a completely approvable case that USCIS won't have any further questions and there won't be anything else that they need to go ahead and make a decision. There are other benefits to using an attorney as well. Namely, strong legal representation gives you the advantage of strategic decision-making. So when you work with an attorney, they'll identify any perceived weaknesses in the documentation and they can anticipate any challenges you may have down the road. So that allows for strategic decision-making about what documents to submit and then when to submit them. So while the goal is always to avoid an RFE, in cases where documentation may be limited, or there's something, there's sometimes value in submitting some of the documentation at the initial filing stage and then reserving other documents to submit in the event of an RFE. Particularly if you know nothing further is going to be available later, you may want to make sure there's something else you can submit if USCIS comes back and asks for more documentation. So that's one of the scenarios where sometimes you won't submit everything up front. And that's a strategic decision that an attorney would help you make. Or sometimes if there's a problem with some of the documentation, if there's something that's weaker or may shorten the approval period, so something like a purchase order that doesn't cover the full period you're asking for, or that kind of thing. In those scenarios, it may be advisable to hold off and only use the weaker document if it's required. So if you get an RFE asking for it. Because there's a chance that USCIS will issue the straight approval without that documentation. So those are strategies that an attorney will use to make sure you get the best possible outcome in light of the available evidence that you have for your specific case. So they'll look at all the documents you have and then make decisions about what should be submitted and when it should be submitted to make sure you get that outcome that you're looking for. So in all, I think the takeaway for RFEs is that while many have chosen to submit bare bones documentation in the wake of federal litigation, which relaxed those program requirements, we don't advise that approach. At ILBSG, we are seeing record numbers of straight approvals because we're filing completely approvable cases with thorough strategic support documentation at the initial filing stage. We're doing the work ahead of time to avoid the headache later, and we're getting the results we want. So we really do advocate for that approach. Next, I'm going to talk a little bit about notices of intent to deny, which can be issued instead of an RFE or even after an RFE, but before a decision is made. So what is a notice of intent to deny? A notice of intent to deny is an inquiry from USCIS letting you know that based on something in the record, they intend to deny the petition unless you can respond and overcome the issue. So this is different from an RFE. With an RFE, they're asking for further documents to determine the merits of the case. And with the notice of intent to deny, they've already made a decision about the case and they're offering you an opportunity to respond and rebut their presumption before they issue the formal denial notice. So notices of intent to deny are very time sensitive. With an RFE, you'll have 84 to 87 days to reply, depending on whether it's mailed or faxed. With a notice of intent to deny, you're going to have 30 to 33 days from the notice date to reply. And if you receive it by mail, by the time you get the physical copy of it in the mail, you'll likely only have about 2 weeks to respond. So it's a very time-sensitive inquiry. And it's also a little bit more serious. Since notice of intent to deny means that they've already made a presumption, the response is typically going to be legal in nature, and that includes case law, legal arguments, and more substantial documentation. So attorney representation is really critical here because the stakes are much higher. Ways to avoid a notice of intent to deny in the first place. Using an attorney to thoroughly review and vet all documents is really important. An attorney can identify inconsistencies or if something seems out of place, raise a flag ahead of time to ensure that all the documentation submitted to USCIS is authentic, accurate, and trustworthy. When you use an attorney is looking at all angles and double checking every part of the petition. So they'll be scrutinizing the signatures and the authenticity of the documents. They'll complete pay stub analysis to ensure the pay stub show that the LCA wages have been properly paid. And that protects the company from both USCIS and DOL inquiries. And then just generally alerting you of any risk that they perceive. An attorney will use their extensive experience and knowledge in working with USCIS to determine what issues USCIS will be looking at and how to avoid a negative inquiry in the first place. If you do receive a notice of intent to deny, an attorney is uniquely equipped to rebut any USCIS presumption with evidence and case law. Since notices of intent to deny typically relate to legal issues with the case, legal argument is critical to overcoming a notice of intent to deny, which means a very strong understanding of the law itself is required. While your company may have never seen an issue raised before, an experienced attorney will likely have handled past cases with similar issues, so they'll know exactly how to address the issue to get that approval. In 2021, we saw far fewer notices of intent to deny than in the past, which is a positive indicator of the current climate. Of the notices of intent to deny that we received, 100% were overcome following our response. So again, the conditions are very favorable right now, even if you do get an RFE or perhaps a notice of intent to deny. So next, I'm going to talk about notices of intent to revoke, which are a little bit different. A notice of intent to revoke is a type of inquiry from USCIS that occurs after the H-1B has already been approved. Similar to a notice of intent to deny, a notice of intent to revoke is a type of notice from USCIS letting you know that they've discovered something, some new information, and they intend to revoke the approval of the H-1B petition unless you can overcome the findings. So similar to notice of intent to deny, except for it comes after the approval. So instead of denying your case, they're taking an already approved case and they're revoking that approval. The response time is the same, so it's still very time sensitive. It's 30 to 33 days, depending on if it's mailed or faxed. Some common scenarios that trigger a notice of intent to revoke include a site visit where the employee is not found. So if USCIS shows up to the work location and the employee is not there, a review of initial evidence in which they discover a discrepancy they didn't notice before. So just because the case is approved, they can always go back and look at the records, see what was in the file, and if they find something that they didn't catch the first time, they can go ahead and issue notice of intent to revoke and address it. Another common scenario would be during compliance checks, which have become really common during COVID. The difference between a site visit and a compliance check is a site visit is usually when they show up on site. A compliance check is usually where they make contact through email or by phone. So during compliance checks, sometimes USCIS discovers that the beneficiary is no longer working in the same capacity indicated in the petition. So maybe it's a different project or the titles changed or the job duties, but USCIS wasn't notified. That can trigger a notice of intent to revoke. Or during subsequent filings where information may be revealed that contradicts the initial filing. So if you file a petition and then you file an amendment and then you file another amendment and then you're filing an extension, but then the pay stubs reveal that sometime between maybe the first two amendments, there was another job location change and you didn't file an amendment. If the pay stubs reveal that, USCIS can issue a notice of intent to revoke on the last approved petition that you didn't maintain status. So those are some common scenarios where we see this occur. When thinking about notices of intent to revoke, the biggest emphasis for me is record keeping. It is absolutely crucial if you participate in the H-1B program that you provide strong, consistent documentation from filing until approval and beyond, and that you keep excellent records of all documentation you submit to USCIS. The only way that you can make sure that all the documentation you submit to USCIS is consistent is to keep excellent records. You should always have complete copies of everything you submit to USCIS, and that ensures that during subsequent filings or during site visits or compliance checks or other inquiries, there's never going to be any discrepancy in information or documentation. Record keeping is crucial and one of the primary values, I believe, of using an immigration attorney. While companies should always keep their own records, using an attorney will mean that you'll always have a duplicate set of records, so you can be absolutely sure of what USCIS has on files. Or if you misplace your records, there's backup copies because your attorney will have copies of everything that is filed. It's really important to me that when you're building or maintaining an existing H-1B program at your company, that you understand that your diligence doesn't end when the case is approved. Record keeping is important for responding to further inquiries from USCIS or in the event of a site visit. And that's particularly true for notices of intent to revoke because those typically relate to something negative in the record. So you need to know what they have on record and you need to make sure that you can compare what was filed in the record and maybe the new information that they discovered. Because sometimes there can be honest mistakes, but if you don't have records, you won't be able to rebut those presumptions. So ways that you can avoid a notice of intent to revoke from the start. One way you can avoid a notice of intent to revoke is to make sure that you have adequate legal representation at every stage. Since notice of intent to revoke are most often issued following compliance checks or where a subsequent filing reveals inconsistent information, having an attorney represent you during a site visit or compliance check and handle all of your filings is an excellent way to avoid a notice of intent to revoke altogether. Because if you use an attorney, then the attorney will carefully review the past filings and ensure your documentation is always accurate and consistent. And that's crucial to success in this area. You know, an attorney is going to be looking at the pay stubs and looking at the documentation and comparing it to what they have previously on record. And if there is an inconsistency or there's something that you've maybe missed, they're going to raise that flag ahead of time before you file it so that you can work to remedy the problem before it's ever discovered. So working with an attorney, you know, an attorney knows what USCIS is looking for, so they're going to be uniquely equipped to scrutinize your records to avoid and mitigate any issues. So next, I'm going to talk about denial notices and then the available avenues for relief if you happen to get an H-1B denial. While obviously a denial notice is the least popular outcome, an H-1B denial is not always the end of the road. In fact, there are usually several options you can explore to still get the outcome you're looking for, even if you get that H-1B denial. So some common reasons for H-1B denial include inadequate documentation. So you just simply don't have the documents to substantiate the terms and conditions of the petition, discrepancies found in the record, a negative site visit or a compliance check, or sometimes as a result of status violations. So where the H-1B beneficiary has violated their status in some way. Ways to avoid H-1B denials include, you know, all the tools we've talked about today, and having strong documentation, carefully prepared petitions, and using an experienced immigration attorney to anticipate and prevent issues. Current denial rates. So denial rates have plummeted since 2020 following the federal litigation, which relaxed the requirements of the H-1B petitions. The first 2 quarters of fiscal year 2021, the denial rate was 7% compared to 28.6% of the same 2 quarters of fiscal year 2020. And new numbers that came out today show that for all of 2021, the denial rate dropped to 4%, which is the lowest denial rate ever on record for USCIS. So that's the lowest we've ever seen denials. At ILBSG, less than 1% of cases in 2021 have been denied. So in past years, USCIS was denying about 1/3 of cases nationwide, you know, at the peak. That's just not the case anymore. USCIS is approving most cases and a large majority without an RFE or further inquiry. So while denials are not a desirable outcome, they are very rare right now. So I want to emphasize that it's an extremely favorable time to utilize the H-1B program. And again, if an H-1B is denied, it doesn't necessarily mean it's the end of the road. You still have options. So first, you'll want to determine if refiling is an option. So with amendments or with H-1B transfers, depending on the timeline of when the denial or cap exempt cases for consular processing, sometimes you'll be able to just refile the petition and you won't have to fight the denial. But if not, there is other relief available. So the other relief available includes motions to reopen and appeals. So the difference between a motion to reopen, a motion to reconsider, and an appeal to the AAO. So a motion to reopen is a motion where you submit new evidence that was not available earlier, but that shows the eligibility at the time you filed the H-1B petition. And there has to obviously, to submit new evidence, you have to be able to prove that it wasn't available earlier, because if it was, it should have been submitted earlier. With a motion to reconsider, you're filing a motion with a legal argument that the denial was incorrect as a matter of law based on the evidence in the record at the time. So there was already enough information that should have been approved. You can file a combo, which is my preferred route, is to file a motion to reopen and reconsider. So to give them new evidence that you didn't have earlier, but also make an argument that, hey, this should have been approved based on what you already had in the record. You know, notwithstanding this new evidence, this was already approvable. The other option is an appeal to the AAO, which is asking a third-party appellate body to review the case from scratch. So when you file a motion to reopen or reconsider or a combination of both, that goes back to USCIS. So you're asking the USCIS officer who made the decision to take a look again. Hey, we think you made a mistake. We'd like this reconsidered. When you file an appeal to the AAO, you're asking a third party to take a fresh look and review it from scratch. So the decision that you usually have to make when you get a denial is whether you're going to fight the denial or whether you're going to refile the petition. So if you can refile a petition, that's almost always the better route for money and timing reasons. MTRs take a long time. 6 to 12 months on average. And while the filing fees may be higher for refiling the H-1B petition rather than filing an MTR, refiling will usually get you much quicker relief and it can be expedited. So MTRs don't qualify for premium processing, but if you refile the petition, you can file it in premium to get that quicker decision. So when refiling is an available option, which is something an experienced immigration attorney would be able to advise you on, that is usually the preferred route. But if you can't and you have to file an MTR or appeal, there's some considerations you'll want to take. So both are time sensitive. From the date of denial, you'll have 30 to 33 days to file a motion or appeal. So kind of similar with the notice of intent to deny or revoke. By the time you get that notice, you're usually going to have about 2 weeks to file. So very time sensitive and obviously high stakes if you're talking about a denial that you don't have the option of refiling. For processing time, so again, MTRs take a really long time. They take about 6 to 12 months. Sometimes they can be faster, but as a benchmark, I'd say 6 to 12 months. Appeals to the AAO can take a really long time. The AAO strives to review cases within 180 days. That's their stated goal for processing times. But most often we see appeals to the AAO take upwards of a year, and it's not uncommon, especially with the backlogs, for that to take 2 to 3 years. So typically someone would explore a motion before they would explore an appeal, unless it's just an egregious error that really warrants appellate review. Other considerations include immigration status considerations. So a pending MTR, so after the H-1B is denied, if you're filing an MTR, the MTR by itself will not provide immigration status. So if you file an MTR, you're going to want to consult with an experienced immigration attorney on any further steps that the beneficiary may need to take to maintain status until a decision is made. And so the benefits of an attorney, and everything we've talked about, there's benefits to the attorney, but particularly when you're talking about motions to reopen or reconsider an appeals, when faced with an H-1B denial, an experienced immigration attorney greatly improves your chances of a favorable outcome. An experienced attorney will know which relief is the best option and how to pursue that relief. Particularly when filing motions and appeals, you want to work with someone who has years of experience in that area. An experienced attorney in this area will be armed with an arsenal of case law and policy and know what works and what doesn't based on previously handled cases. If a motion or appeal is your last option and refiling isn't possible, you want to make sure you put forth the strongest argument possible to overcome the denial. Again, a denial notice obviously isn't the outcome anyone wants when they file an H-1B petition, but if you use a good attorney, you can overcome a denial on motion or appeal or work to explore alternate options. At ILBSG, we've had huge success in filing MTRs, so it's definitely an option to bear in mind and something to keep in your toolbox. And again, denial rates are at a record low, so while no one wants to think about a denial, they are very rare at the moment. So just some takeaways from today's presentations. The best way to improve outcomes and increase your odds of H-1B approval is to use an experienced immigration attorney to carefully strategize and prepare the initial petition. All the things that Attorney Amaro was talking about. You want to prepare and submit thorough, carefully vetted support documentation at the initial filing stage to avoid an RFE altogether, and to always keep adequate records of everything submitted to USCIS to ensure complete compliance and consistency, so that if there isn't a further inquiry, whether a site visit, a compliance check, or an RFE, or a noticement to deny, you'll be in the best possible position to respond and get the outcome you're looking for. Again, RFE rates are down, denial rates are at a record low, so it's a very favorable climate to utilize the H-1B program. By taking advantage of the current climate in combination with using a skilled, experienced immigration attorney, you can really maximize your success and grow your company's H-1B program. Thank you for your time. I think we're now going to turn to the question and answer portion of the presentation.
That's right. Thank you, Julia. Thank you very much. We did have some questions come in. One has already been answered. Praveen, would you like to answer the question regarding, let me just pull it up quick. What are the odds of success and what can you do to increase your odds of success in the lottery portion of the H-1B program?
That's pretty much the popular question we always get when I get to speak with some students, especially because we also see in unfortunate situations that some people might have been waiting for them to be selected in the quota for more than 3 years, 4 years. Year after year, they don't get selected. Then obviously that's their next question is, how do I increase my odds of selection? So again, properly submitting the application is of course the first step. As Julia was highlighting in all her presentation that having an attorney representation while you are making registration, then filing the H-1B petition is very important, because we have also seen in some of the situations that maybe the registration was not done properly, or it was duplicated within the same company, and which led to consequences where they ended up not getting selected. So having said that, then the odds of getting selected, probably anything that you can do from your end, that USCIS clearly says, or the guideline says, that you're not supposed to be registering with multiple employers to circumvent, for the whole purpose of circumventing the quota. So that's wrong, and USCIS can actually take you out of the system and might even cancel the selection if that happens. Having said that, there is a fine line again in this current economy, where technology workers are, especially the H-1B workers with the specialty occupation requirement, are highly sought. If you get multiple offers from different employers, there's nothing wrong in accepting. So if you are currently in the US or outside the US, but still get multiple offers from different employers, as long as it's a bona fide job offer and the employer are willing to file for the H-1B petition, then absolutely you can go for that. That might increase your chances, but at the same time, you cannot use the same thing for your advantage to circumvent the quota and to get selected in the lottery. So what that means is, it's about the employers who can actually do the registration. You cannot influence the employers to do this. Then as long as you have multiple offers, maybe you have a skill, you have a background which really highly sought by the industry, then multiple employers filed for your H-1B, obviously you'll have more chances to get selected. And of course, that's also been the disadvantage in the current lottery system, that people who have been selected at multiple employers avail only one H-1B, and that actually leads to the cancellation of the numbers. And then that's the reason why you see the second and the third lotteries coming into the picture at this point. So while we are all debating if this is the right system or not, then the only way is to see that you have the skills which are highly essential, are in high demand in this economy, which might actually help you secure multiple job offers, and then probably that might help you. But with the fine line that you cannot influence the employers to do this. At the same time, you cannot use this to circumvent the quota. The whole strategy should not be to circumvent the quota. That is totally wrong.
Thank you, Praveen. We did get one question just come in for someone who's kind of new to this. Their question is any of this necessary if the employee stays in their home country?
So I did not get the question right, though. So is the H-1B lottery necessary if the employee is outside the US?
So if the employee is outside the US in their home country, and they're going to work for a company
so do they have
in their home
file for
country.
H-1B? Okay, so remote work is allowed, then as long as the person is not in the US, then obviously an employer, a US employer, can always hire a foreign contractor in the foreign land that does not need immigration filing. So that's absolutely allowed. But again, there are certain restrictions in certain industries that you cannot hire a foreign worker. And maybe it's also an industry norm. For example, none of the financial industry, financial companies would actually hire someone from outside the US because of the laws which are governing their industry, their companies. For example, banks would not do it because the financial information cannot go outside the US, but it can under certain guidelines. So those actually govern this, but otherwise for the immigration, it's always okay to hire a foreign worker in the foreign land, and you don't need any immigration filing for that.
Okay, thank you.
If that
And one last question, unless anybody has anything else, again, feel free to pop them in the chat, the Q&A, raise your hand, lots of options. But one other question that was submitted previously is, what's the most common mistake made when filing for an H-1B, and what can be done to address that, Julia?
Sure. So, you know, a couple different places that we see companies have missteps, but I think that the number one piece of advice is it's never advisable to file the petition on your own and then only seek, legal help or to hire an attorney if you get an inquiry from USCIS. So when you do it that way, when you file it on your own and then you just get the RFE and then bring that to an attorney, if there has been any kind of mistake made in the forms or the filing or the LCA, there's nothing that the immigration attorney is going to be able to do to remedy those mistakes because we can't go back and refile that petition. So if you filed your LCA with a bad SOC code that doesn't show a specialty occupation, certainly an immigration attorney, an experienced attorney is going to be able to help and try to make a legal argument about that case. But it could have been avoided altogether if you filed using a correct SOC code. So, the number one mistake I see, I think, is, waiting to hire an attorney until you've already got a problem, where it's better to use an attorney from the beginning. And I think people tend to do that because they think they can file it on their own and it's maybe more cost effective and only hire an attorney if they really need one. But if you end up needing an attorney later, it's typically because there's been some missteps with the filing, and then the likelihood of you getting the approval or the outcome you want has been diminished because you've handled the filing on your own and there's only going to be so much the attorney can do. So I think, having proper legal representation from the very beginning is the best way to avoid any of those mistakes. And some of the more common mistakes we see, LCA, missteps or SOC codes, all of that can be avoided if you have an attorney from the very beginning and you have that attorney represent you through the petition, any RFE, during a compliance check, anything like that, to make sure that strong, consistent documentation goes to USCIS and you don't have any sort of red flags or negative information ever make it to USCIS.
That's great. Thank you so much. I don't see any other questions coming in. So we'll start wrapping up our webinar. I just wanted to share with you, as I mentioned at the beginning, how highly our clients rate us. And this is just an example of one of the pieces of feedback we've gotten from one of our long-term clients. If you do have any questions, we're here to help. You can find our website, our phone number. Feel free to email me, Dorothy@bizlegalservices.com, if we can be of any help. And if you have any other questions following this webinar, you can submit them there as well. Thank you, attorneys. And we will have this recording up and available. So if you want to go back and rewatch your favorite part, you can do that. Thanks, everybody.
Thank you, Dorothy. Thank you.
Bye-bye.
Thank you, Amaru.